And what I'm going to talk about today is using joint ownership to reduce probate tax as a strategy. Won't be that focused on necessarily on estate, although I'll show you a couple of things of how estate can deal with that. But it's more just a general topic and discussion. So the concept, and then we'll go through some documents. The concept is that you take an asset that is owned by the testator and you change title to that asset so that it is owned not just by the testator, but by the testator and, for example, their son, okay, a child. And the concept there is, although legal title is in both names, both the testator and the son's names, that the real ownership, the beneficial ownership of the asset is still owned by the parent, by the client, the testator. And yet, even though the real ownership is with the client, when they die, by operation of law, just by law, the son becomes the sole owner on title. And that way you don't need probate and go to the financial institution and prove that the will is valid or anything like that and pay probate tax, depending on your strategy, for that asset. You wouldn't need probate to get that asset from the deceased's name into the son's name. And so that's the overall strategy of joint ownership. It's to allow for assets to pass automatically to someone else on death without requiring probate of the will. Now, that causes its own problems because in a sense, it's a bit of a fiction that you could have, the true owner being the deceased, but the name on title is someone else. And there is a famous Supreme Court of Canada case called Pecore, P-E-C-O-R-E, that said, well, this is such a common scenario where parents are being told by financial advisors, by lawyers, by other advisors, well, we can avoid probate tax by putting your kid's name on title. Or, you're getting old, mom, why don't you put my name on title to the bank accounts and the investments so I can make the decisions for you just for management and convenience purposes. So that's what was happening. And the Supreme Court was asked whether, in that case, does the asset belong to the child who's on title, or should it really belong to the estate? Because the parent didn't really mean it as a true gift to that child, but instead meant it only for convenience purposes or only to avoid probate tax, when what they really wanted is the value of that asset to go under their will. And the Supreme Court of Canada said, well, when it's a child, an adult child and a parent, and the parent puts an adult child's name on title as joint owner, the real effect, the default effect, is that asset belongs to the parent, not to the child. And therefore, when they die, it's part of their estate, unless there's evidence to the contrary. So that is the rule that we have right now. So whenever we see a situation where our client, the parent, let's say, has ownership of a piece of an asset with an adult child, we should have a red flag that pops in our head. And I'm just going to share my screen for a second because there is this issue. Who does that asset belong to on death? And as an example, let's say Claire made Mitchell the joint owner. Mitchell's a child, made Mitchell the joint owner of this investment portfolio for $500,000 because someone told them, oh yes, this is a great way to reduce probate tax because probate won't be necessary when you die because Mitchell, by virtue of being a joint owner, becomes the sole owner on your death. So what estate does is it warns you of those situations. And one of the advisor insights is this warning that says, by the way, the investment portfolio is owned jointly with Mitchell in the descendants only scenario. Consider documenting the client's intention regarding whether this is a true gift, meaning that they're supposed to really receive that full amount, or it's held for the estate. It's really part of the will. And that's called a resulting trust. When something is held for someone else, because it's their asset, the real ownership, that's called a resulting trust. And so that is the warning that estate gives you anytime you've documented that an asset is owned jointly between a parent and anyone else, really. But that being said, it warns you, now what do you do? So we have a couple of documents, because really there's only basically two options there. Either the client means for Mitchell to receive that investment portfolio, or as a true gift. So when they die, Mitchell, you get the investment portfolio, not part of the will, not part of anything else. Or Mitchell, you get title to that investment portfolio, but you've got to deal with it on the same terms as the will. You're holding it on a resulting trust for the estate. So the two documents to basically document those two options. The first one I'm going to show you is what I call a declaration of intention with a gift of the right of survivorship. So this is meaning it's a true, the gift is or the transfer into joint ownership is meant to be a true gift to Mitchell when Claire dies. And so this document saying, look, I've put my child's name on title, and I really mean it. They're to get that asset when I die, okay? And it sets out the intention, because when these fights occur, the argument is, oh, mom didn't mean it as a true gift, or mom did mean it as a true gift. And so this clears that up. And so this is the document that you might consider having the client sign, in this case, Claire, sign to say, I meant this to be a true gift when I die of the investment portfolio to Mitchell, okay? And that's what this document says. We will circulate this to anyone who's on this call who would like it. Eventually we'll add it to eState, so it'll be generated automatically. But for now, you'll just have it as a separate document. So this is the document used in option one, where you mean it as a true gift. And then we have the opposite, where, look, I'm doing it just to save probate tax, so that we don't need probate when I die for this asset. And when I'm putting your name on it, it's not really yours. It's really mine, Claire says. It's really the parents during their lifetime. And when they die, it's really their estates. And so that's what this declaration of intention confirms, that I'm only doing it to allow them to manage it and to reduce probate tax, okay? But it's still mine through my lifetime and my estates when I die, okay? So those are those two documents. And I'm just gonna say a few more things about that and then open the floor to questions before we get to some other documents. Just because you don't need probate to deal with this asset. So I'm going to take this scenario. Claire puts this joint account, this investment account, in joint ownership with Mitchell because she wants to avoid the probate tax on it. Well, the problem is the true ownership of that belongs to the estate, and therefore it's covered by the will. And therefore you have to pay probate tax if the will covers that asset. So if you have one will and you have to probate that will for any other assets, then you have to include the value of this investment portfolio, because it's not a true gift. It really belongs to the estate. So in essence, you haven't avoided probate tax with this strategy. You need a companion to that strategy. And that's a separate will to deal with assets like this that are held on a resulting trust for the estate, or else you're going to be stuck paying probate tax, even though you didn't need probate to deal with it. And so one of the things that eState can help with is using a separate will for those assets. So in the provisions tab, we know we're going to use a multiple will strategy for this, and we're going to want to include trust assets as an asset in the secondary will. Okay, so we'll want to make sure that's checked off. so that when we generate the multiple will, we've covered off, we know that those assets that are held on a resulting trust, sorry, I keep having to move this stuff around, are going to be governed by the will that doesn't need probate. And by doing that, not only is probate not needed for the to transfer that investment account to Mitchell, it'll go automatically, but there's no probate tax either, because it's dealt with in a will that isn't subject to probate. And I'm just going to show you the wording of that clause in the secondary will. So what assets are we talking about? We're talking about trust assets, assets that are held on a resulting trust for the benefit of my estate. Oops. So let me just show that to you. So in the secondary will, we've got assets that are held in trust for me or my benefit or the benefit of my estate as the date of death. And so that's exactly that investment portfolio that was that Mitchell's name was put on, but it wasn't intended as a true gift. It was intended to be part of the rest of the estate. But so you need those two components. You need the child on title as a joint owner, and you need a secondary will. There are exceptions to that rule, but let's stop there for a second. And so that's how you can, in essence, have your cake and eat it too. Have an asset that's valuable, put a kid's name on title, but not have them as the true owner, and still save probate tax. I'm going to open the floor to some questions and to see if anybody has any questions to talk about this step. I'm going to talk about a couple of other steps as well, but see if anybody has any questions. All right.
Just to clarify one thing, sorry, Jordy.
Yeah.
So if this child is the only child,
yes,
then we can assume that we don't have to do all of this, that if the parent just puts their name on the asset, then since there's nobody else going to be arguing that this is a problem. So this is basically only for a situation in which there are more potential beneficiaries than this one child.
I would still do a deed of gift intending to confirm the right of survivorship is intended to be both legal and beneficial. Why? Okay. Because if you probate the will for other assets, the ministry could take the position, look, PCOR applies to this, and so really it's part of the estate. So I would document that in case they give you trouble, because they could take that position. Really? And you would have all kinds of arguments to say, well, clearly it's going to the same person and all of that, and that's why I would do that even in a single, for a single child.
Okay, so multiple wills, even for a single child?
No, not necessarily multiple wills, because in that case, like, so if the intention is it's a true gift of the beneficial ownership, then if you document that, then that's fine. That's like a joint ownership between spouses or anything else. You know, I don't think you have a problem there, subject to a couple of things from a probate tax point of view. It's always safer, in my view, to do multiple wills. I like doing multiple wills as a matter of course, unless you've got clients who, you know, really want simple. But I think you can make a pretty good argument that multiple wills are a benefit to the executors, in that they don't have to worry about personal effects. And if down the road they decide to take this kind of strategy, you know, it's just helpful. So, and with estate, the difference is, well, there's no difference in time. So that's why I'm deferring more to that. But I do want to raise a couple of downsides, Nancy, because you've raised a couple of issues. So when you put a kid's name on title, there's a transfer, there's a disposition, right, of 50%. Now, so the problem becomes the tax, the income tax issues. Maybe you've saved probate tax, but then there's the income tax issues. And if you take the investment portfolio is in my example, and I put the kid on there, and I did it as a true gift. What we have, I think it was, where was it? Yeah, here. What we have is a disposition for tax purposes now, right now, when I put the kid's name on there. And so I've just triggered capital gains potentially on this asset. What else have I done? If it's a true gift, well, I've lost control, I may no longer have 100% control over that asset. I've made it susceptible to Mitchell's creditors, to Mitchell's spouse potentially. I've given rise to issues about what happens if Mitchell becomes mentally incapable, and now I have to deal with his guardian if he's got one, or he doesn't have a power of attorney, and now I'm screwed. I could have a falling out with Mitchell, and he could say, you know what, I'm taking all this money. And so there's lots of downsides to this kind of planning. And, I think it's not as simple, nothing that simple is without consequences. I think you're better off. And a big example is a principal residence. If I put Mitchell on as a, which you see all the time, a child put on title to a principal residence without documentation, then there could be an argument that it's no longer, it's a disposition, and there's no longer a principal residence exemption that applies to 100% of the home, that Mitchell is now a 50% owner of this home. And it's not his principal residence. I've just taken a tax-free asset and now made it a taxable asset, because now I only own 50% of it, and a person who's not, doesn't own it as a principal residence owns the other 50%. So it's something that sounds simple to avoid probate tax, and who's going to get sued? Of course, we're going to get sued when something goes untoward, and people expect it to be done. Well, it's very simple. Just put my kid's name on title, but it's not just that document. It's the ramifications of all of those issues. And so, yes.
It's James. A couple things is obviously the new disclosure rules for principal residence on a change of ownership on an annual basis comes into play to claim your principal resident exemption at that point.
Right.
Right. As well as, I guess, the commingling problem, as you said, moving forward as to whether or not it retains that status or not.
Yeah, I think I'm just going to turn up my volume a little bit just so you can hear it as well. Yeah, it's not a simple, and that brings me to my next point, and that is, explaining this to the client. And so I have this sort of memo that when somebody tells me, oh, I've been told to put everything joint with a kid, or what are my options? Even because it's almost you're damned if you do, you're damned if you don't. People are now becoming so aware of this that if you don't raise this with your client and then they die, the kids come to you and say, why didn't you tell mom to put things jointly with one of us, and we could have saved probate tax? So I'm not sure I'd do it on every plan, but here is the idea of how what the benefit is, and then the problems, tell me if you want to do it. And often when I've gone through these, clients back away. They're like, I understand. I'm really the true owner and all that. I say, look, you can be the true owner, and but if your kids refuse to sign off, then you got to sue them and say, I'm the true owner. So you may be right in law, and you may be right ultimately, but there may be a hassle. And of course we see often the things that go wrong. So, and I'm happy to share that with anybody who's interested as well, as a sort of a memo, and you feel free to sort of, play around with it. Obviously, it's just a sample for you, but it does address some of the problems with, transferring assets and taxes and difficult creditor issues and things like that. So, because there's all kinds of problems. So that's that, and I'm happy to send that to you. so yeah, so you just maybe just let Michaela know. That's probably the best way, and she can make sure it gets out to everybody. So we have about 8 minutes left for any questions on joint ownership. We haven't talked about other ways of doing it, but I just want to talk just today about this idea of joint, putting a kid on title. So any other questions?
Jordy, I have a question.
Sure, Blake.
Yeah, this declaration of gift, it seems to be fraught with potential problems, as you outlined. However, it would seem to make more sense always to go the intention of resulting trust. Would it not? Would you, for example, the matrimonial home, if you owned it with, if you changed it to joint with your adult child, yes, and you did the declaration of intention of resulting trust,
yes,
do you lose that primary residence or principal residence
exemption? So let me just close. I want to close all the tabs here. So let me just pull that up on my screen for a second. So the general rule that I first of all, I always say, look, check with your account. But what I could say is my general understanding is that it doesn't affect the principal residence exemption if it's held on a resulting trust. The reason I would get this document signed as well and not just rely on the presumption is it's only a presumption. And so I would want, if CRA ever comes out and says, oh, we think that you disposed of half the interest, you've got a document to back that up, that you didn't transfer beneficial ownership. Anybody have any experience on this to the contrary, where CRA takes a different position? Because I've generally seen that CRA takes this, confirms that this doesn't affect the principal residence exemption. Because it's a pretty common planning technique. And but I always say, look, you're not relying, I'm not giving you advice on that it won't be an issue. In fact, I always warn them, because CRA could change their mind, right? I mean, it's nowhere written in, it's not in the Income Tax Act that says, oh, this, so it's an interpretation, which is always subject to, especially if they're looking for more tax, which they probably will be down the road.
Definitely.
Right. So that's why, I just say, look, I don't give tax advice. So I just say you got to confirm it with your tax advisor. I find that accountants are generally more like laissez-faire with that. They're like, yeah, I think it's fine. It's okay. Yeah. So.
I think, Jordy, it does somehow also connect to how the probate is handled with that asset.
Yeah, no, I think
if it's included in probate or not, even though it is a resulting trust, as
well, put it this way. Yeah, I mean, the rule of thumb is if it's an asset that's governed by the will that's subject to probate, then you have to pay probate tax on it. If it's governed by a will that's not subject to probate, then you don't have to pay probate tax on it. That's why you need this separate will, and that's where lots and lots and lots of people fall down, because they do part of it and they don't do the second part of it, which is the secondary will. The other thing I would point out, and I mentioned sort of doing multiple wills more frequently now, is if you've got an older person, and you know that they have, that they're big into tax savings or whatever else, and you think they might do this down the road, or you think their power of attorney, their attorney for property might do it down the road, and we can argue about whether they can do it or not. Having a secondary will in place that deals with those kinds of assets already in place, it's there. They can do it on their own anytime they want. And I often say that to them. We've done these multiple wills for you. If down the road you decide to put one of your kids on title, your will covers that already. You've got a second will that's going to avoid probate tax on that. Don't forget to do a declaration of intention, but at least the will's in place. So another reason to encourage your clients, especially, older clients, to do multiple wills. And you can, the reality is that you should be charging more for multiple wills because they are more complicated. So, got 3 minutes left. If anybody's got any questions. By the way, this webinar, as all future advanced webinars, will qualify for CBD credits. The provider is eState Academy, and we can forward that to you, and we'll take care of making sure that the Law Society has accredited us to do these webinars. So. Any other questions? Great. Well, thanks everybody. Teresa, are you trying to say something? Oh, I don't know what's going on. So thanks everybody, and have a good afternoon. We'll see you again next week. And sorry, Teresa, your mic's not working. I will stick around so till it's working, but everyone else, feel free to sign off.
Hey, Jordy, James.
Hey, James.
Yeah, so obviously I'm not from your side of the fence, but I obviously on the front lines, and this is a very significant problem that prevails, and the assumptions that are being made in my experience of as people are evolving, particularly as they're getting older, that we're finding these joint ownerships are becoming, even written in the in Snowbird magazines and all these sort of things on the way to mitigate the aspects of probate tax, maybe flow of assets sooner to get in the hands of those that believe they're deserving.
Yeah.
But it's something that is a common thought that this is all you do. And as you've said, it's a bit of a contact sport.
Yeah, it's more complicated. It sounds simple, but it's more complicated. And that's where we're, as good practitioners, the people who are on this and pay attention know that it's more complicated, and trying to avoid, liability for us by knowing what to do. So thanks, James. Good
Yes,
point.
I'd like to give the liability over to you guys, okay?
Yes. So Teresa had a question.
Sure.
Can you include life insurance payable to the estate under the secondary will? Can you give an example of other lives, life insurance, and how it's covered under the second will? Yeah, so basically, let's talk about other lives, life insurance. Typically, a life insurance company, if I as the, I own a life insurance policy on someone else's life. And what I want to do is when I die, give that life insurance policy that I own, I want to transfer ownership to the life insured, to the person whose life is insured under that policy. Typically, probate isn't necessary to do that. And so that's why I would put that, why we include that in the secondary will. The idea of having life insurance payable to the estate under the secondary will, I am not comfortable with that yet. I haven't seen anything from the ministry that would say, that it's governed by the secondary will. Partially because and I know there's case law, the Roseanne case about how an insurance company will pay it out without probate, and is required to pay it out without probate, but. If they do require probate, then I think you're going to be required to pay probate tax on that insurance. So I'd rather pay it to the trustees as a separate insurance trust and do it that way.
Yeah, there was this morning, I was in a session with the group that was discussing this on the aspects of the changes with the concerns around beneficiary designations. And seemingly the courts taking a different view. So this is
right.
Something that's a concern.
Well, yeah, and the fact, and maybe we can save that for another week, but the whole idea about PCOR, this idea of resulting trust, applying not only to joint ownership with one kid, but a beneficiary designation applying as well. So, but that's probably a good topic for another day for sure. Great.
All right, Jordy, thank you very much.
Thank
as
you,
always.
everybody. Have a great
Insightful.
afternoon. And feel free, if you have another question or whatever, just to email me and I'm happy to jump on a call or whatever. Okay. Thanks again, everyone. Bye-bye.